So the SCOTUS case study which I had was McCulloch versus Maryland. It all started in 1816 when Congress established the Second Bank of the United States. In 1818, the state of Maryland passed a legislation to impose taxes on the bank. James W. McCulloch, the cashier of the Baltimore branch of the bank, refused to pay the tax. The state appeals court held that the second bank was unconstitutional because the Constitution did not specifically state that the federal government could charter a bank. After that, McCulloch appealed to the U.S. Supreme Court. The constitutional questions of the case were, did Congress have the authority to establish the bank? And did the Maryland law unconstitutionally interfere with congressional powers? So I thought the possible method of handling the case could have been ruling that under the necessary and proper clause, the federal government could charter a bank. Also, the ruling could have established the boundaries of federal government over state government by stating that the national government is superior to a state government. The decision of the court was made on March 6, 1819. It was in a unanimous decision that the court held that Congress had the power to incorporate the bank and that Maryland could not tax instruments of the national government employed in execution of constitutional powers. Through the necessary and proper clause, Article 1, Section 8, Chief Justice John Marshall noted that Congress possessed powers not explicitly outlined in the U.S. Constitution. Through his decision, Marshall redefined necessary to mean appropriate and legitimate, covering all methods of furthering objectives covered by the enumerated powers. Marshall also held that while the states retain the power of taxation, the Constitution and the laws made by the national government are supreme and cannot be controlled by the states. John Marshall quotes this in his decision. The Constitution and the laws made in pursuance thereof are supreme. They control that Constitution and laws of the respective states, and cannot be controlled by them. In order to make the decision of the court valid, legal theories were thought of. One of them was observed by Marshall, that the second bank was no different from the first bank of the United States, of which the constitutionality had not been challenged. The first Bank of the United States was established through the Act of 10th April, which Marshall describes as a law made by the federal government. Another theory described by Marshall was the ratification of the Constitution, claiming that the Constitution was read and approved by the states assembled during its creation. The ratification of the Constitution implies that those states have accepted the document as supreme and the overall holder of power over state power, since it makes up the entire country's government. So this is just further reasoning of the court's decision, which are excerpts from the opinion that John Marshall had written. The first excerpt refers to the Supremacy Clause, which states that this Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the state legislatures must consider that. The second excerpt states that the government which has a right to do an act, which is explicitly stated in the Constitution, and has imposed on it the duty of performing that act, must, according to the dictates of reason, be allowed to select the means. So technically, the Second Bank of the United States is a method of carrying out an explicitly stated act in the Constitution, which states that the federal government can collect taxes, and the Second Bank of the United States is a method of collecting taxes in a way. These are the answers to the constitutional questions which were addressed earlier. So the first one, did Congress have the authority to establish the bank? Yes. According to the Supreme Court, they decided that Congress did have the power to establish a national bank, not as an enumerated power or explicit, but as an implied power granted by the Constitution. The Supreme Court found that the Constitution grants Congress the explicit power to levy taxes, which I had said earlier, and regulate currency, which means that they need a method of doing so, which is the Second Bank of the United States. The second question, did the Maryland law unconstitutionally interfere with the congressional powers? And the Supreme Court did find that they did. The Maryland power did unconstitutionally interfere with the congressional powers, seeing as the court decided that Congress needed the national bank to perform its constitutional duties. Maryland's attempt to tax the bank was unconstitutional and violated federal supremacy. The Supreme Court found that federal law had supremacy or authority over state laws, and that states could not interfere with federal power, which again states or restates the Supremacy Clause. McCulloch versus Maryland did have its own impact and significance. So the case set the boundaries between state government and federal government. According to the Supreme Court Chief Justice John Marshall, the federal government's establishment of the Second Bank of the United States was constitutional, and the states, such as Maryland, could not tax a federally established institution. And here, the state power was overtaken by federal power. Another significance would be the doctrine of implied powers, which John Marshall does state in his opinion. One of the biggest impacts of the court's decision on this case, I feel, was on federalism. One of the effects was that federal government had powers that are not listed in the Constitution, and the decision enhanced federal power and gave the federal government ways to achieve the responsibilities that they were given to in the Constitution. Again, the Second Bank of the United States. Another effect on federalism was the decision established and reaffirmed the fact that the United States has a strong central government and that federal law has authority over state law. Since McCulloch versus Maryland stated the necessary and proper clause into its decision, I thought these two cases were about similar to the case because they also incorporated the necessary and proper clause into their decision. And those were Prince versus the United States and Missouri versus Holland. So the context behind Missouri versus Holland taking place is that in December 1916, the United States and Great Britain entered into a treaty to protect a number of migratory birds in the U.S. and Canada. Congress passed the Migratory Bird Treaty Act in 1918 in order to facilitate enforcement of the treaty. When Ray P. Holland, the U.S. game warden, threatened to arrest citizens of Missouri for violating the act, the state of Missouri challenged the treaty. The state argued that the Constitution gave Congress no enumerated power to regulate migratory bird hunting, and thus the regulation of such hunting was the province of the states according to the 10th Amendment. So the decision was 7-2 for Holland, and the constitutional question was, did the treaty infringe upon rights reserved to the states by the 10th Amendment? And the reasoning for the decision taken by the court was that the court assumed that Congress could use the necessary and proper clause to carry into execution the treaty power by implementing and extending the substantive terms of a treaty. The court also reasoned that the Supremacy Clause, Article 5, Clause 2, renders treaties the supreme law of the land, a finding that trumps any state-level concerns with regard to the provisions of any treaty. Again, this does have impact on federalism because federal law was taken into consideration over state law. The other court case which seems similar to McCulloch versus Maryland was Prince versus United States, which took place after the Brady Handgun Violence Prevention Act, Brady Bill, was passed, which required local chief law enforcement officers, CLEOs, to perform background checks on prospective handgun purchasers until such time as the Attorney General establishes a federal system for this purpose. County Sheriffs J. Prince and Richard Mack separately challenged the constitutionality of this provision of the Brady Bill on behalf of the CLEOs in Montana and Arizona, respectively. In both cases, district courts found the background checks to be unconstitutional, but ruled that since this requirement is severable from the rest of the Brady Bill, a voluntary background check system could remain. So anybody who didn't have an issue with getting their background checked, then the system can still be set. But if somebody doesn't want their background to be checked, they also have that option. They can't be forced to let their background check be done. And the decision was 5-4 for Prince. The constitutional question was using the necessary and proper clause of Article 1 as justification. Can Congress temporarily require state CLEOs to regulate handgun purchases by performing the duties called for by Brady Bill's handgun applicant background check? So the reasoning for the decision was a federal law compelling state executive officials to implement federal gun registration requirements was not proper because it did not respect the federal state boundaries that were part of the Constitution's background or structure. So basically, the necessary and proper clause was not considered in this case. So basically, McCulloch versus Maryland was about a state government trying to tax a federal government's bank. So I thought this was really cute where Pooh is the federal government and he says that I love honey, but what I don't love is a state government taxing my bank branch, because I thought it was cute. And then in the bottom, it's a political cartoon, which I found. So it's pretty self-explanatory when you look at it. It's probably used on the AP exam. And there's also a hint that it's a state bank taxing a national bank. That's also a nice way to remember it. And then if you like quotes, a quote is also a good way to remember the court case by John Marshall. The power to tax is the power to destroy. So when he stated that, he said that states have no power by taxation or otherwise to retard, impede, or control the laws of the federal government, and thus the law imposing a tax on the Bank of the United States is unconstitutional and void.